Steve Palmer here again with the show at 511. Another guest, Michael Hunter. We're going to, a little bit interesting, right? Because you're a prosecutor. Everybody knows, or at least the millions of Lawyer Talk listeners now know that I'm a defense lawyer, but we're going to get into that. Why don't we just sort of start, what's your background?
Sure. I came out of a small one-stoplight town in northern Ohio called New London. I joined the Air Force right out of high school. I was in the Air Force from 1990 to 1998. I was a security policeman and a criminal investigator, and that was really the time where I first kind of got exposed to working with JAG officers that were actual prosecutors. And it's the most cliche thing in the world. That was the time that the movie A Few Good Men came out.
Yeah.
And instead of wanting to be Danny Kaffee, Tom Cruise's character, I wanted to be Kevin Bacon's character, Jack Ross.
So you knew you were going to be a prosecutor from the start?
Once I started being around JAG officers, while I was doing investigations, I would see that and be like, that looks interesting. That might be something I wanted to do.
Now, you're Air Force. You went out of high school to the Air Force?
Yeah.
And then college?
And then college. I did a lot of college while I was in the Air Force, and I got out in 98, came to Ohio State, finished up a BA in Criminology, and then a year later I started law school up in Cleveland Marshall College of Law in Cleveland.
Gotcha. Now, somebody else, Mark Zatawa, a good friend of mine, he's a criminal defense lawyer. He sat here with me on one of these, and he started as a prosecutor, but quickly ended up on the defense side. You've stuck with it the entire time.
Yeah, I'm a G-man at heart. I come from a law enforcement background, obviously, and then it's just I feel like you can have the most impact as a prosecutor. You actually have your hands on the levers of deciding what cases come in, which cases get prosecuted, how they get prosecuted. You have a lot of discretion in our office about how to resolve cases. And, I think that one of the roles as a prosecutor in federal court is the district court judges really kind of depend on you to be the baseline of, here's the facts, here's the law, I'm not going to try to shade anything to gain an advantage. You really kind of play that role. And I read a book when I was in law school by Alan Dershowitz called Letters to a Young Lawyer, and one of the things he said is, if you need to wear the white hat, then you need to go to work for the government because you're not always going to get to do that. And that really resonated with me. Like, yeah, I kind of need to wear the white hat. And that's what I feel like I get to do the vast majority of the time.
Well, let's back up a little bit because you threw in a lot there. You went to law school where?
Cleveland Marshall.
All right. And after that, I read your bio, of course, but you were a clerk for a federal judge out in D.C.
Yeah, I went to D.C. Because I had so much federal time in from the Air Force. I went to D.C. with the whole idea of getting the legal career started there and eventually bringing it back here, back home to Ohio. And I was fortunate enough to meet John Fisher. He was the appellate chief of the D.C. U.S. Attorney's Office. And I met him. He just happened to be from Mount Vernon up the road, so we just kind of chit-chatted about that. And like a week later, he got nominated by President Bush to go to the D.C. Court of Appeals. And I begged him to take me with him as his law clerk, so I was his first law clerk.
Well, I mean, when we use the term, now this is an important distinction because there's notions of law clerks out there and then there's notions of a law clerk for a federal judge. That's a big deal. I mean, that's not, I don't care who you know, it requires some intellect, it requires some ability. I mean, you got to be good at what you do in order to even get selected for that.
It's pretty competitive, and it's just like serendipity that I met this guy, and it resonated with him that I was also from a small town in Ohio, because there were certainly more qualified people than me that applied. I think he liked me. I was a little older. I really kind of came at that interview with the judge of like, I'm not just going to be your law clerk, I'll be a member of your staff, and whatever you need done, that's kind of my role. When federal judges get appointed, there's a very big ceremony called investiture, where they have literally hundreds of people come in as their invited guests. Like I was like, I will pick people up at the airport, I will be your guy. And so I really feel like, because you know that if you are lucky enough to get that clerkship and you do well and you have a judge like John Fisher vouching for you, it really helps punch your ticket to whatever comes next. And for me, whatever came next was coming into the U.S. Attorney's Office in D.C. He was kind of known as the gold standard around there, so when he's vouching for you to come back in, it makes it a lot easier.
Sure. And not to beat the dead horse, but as a law clerk, and I was never a federal law clerk, although I had an opportunity at one point, but my perception of it is you just get to know a lot of law. You get to see a lot of stuff, you get to learn a lot of stuff, you get to work on a lot of diverse type of cases. And I imagine the experience you got there is probably invaluable for what you're doing now. Absolutely.
It was a little ironic in that I'm a criminal law guy, and for the entire clerkship, we were recused from all criminal cases because he had been the appellate chief for the U.S. Attorney's Office. So we did nothing but a diet of administrative law, civil law cases in D.C. There's a lot of real estate law cases about the way you sell buildings and properties in there. And so for a year, I did nothing but civil law, which was really, really good because it's not where my interests lie, and you kind of have to get up to speed. The standards are set very high. So that was interesting. And then the other part about just being around a federal judge in a clerkship is it's a very intimate setting. There's you, an administrative assistant, maybe one other law clerk, and the judge, and you're one of 4 or 5 people that get to talk to them every day, pick their mind about how they're thinking about cases. I probably got to watch 60 or 70 oral arguments during that time, and you immediately go in and talk to the judge about the argument that was made and what he thought of the lawyers and what worked and what didn't work. So absolutely invaluable for learning how to read a court, know how judges think about things, and then just to be around people that have risen to that level. Judge Fisher thinks of himself as a regular guy. He's not. He's a genius.
Yeah.
And you get to be around them and just kind of be part of their thought process and hear how they think about things. It was invaluable, but it also, about halfway through the clerkship, I told him that I wanted to be a prosecutor and go to the U.S. Attorney's office. And in a very backhanded compliment, he's like, I think your strengths would be better on your feet in a courtroom than all this appellate stuff, which is a very nice way of saying, you're not an egghead like me, so you're probably better off being in a courtroom on your feet.
No,
he wasn't wrong.
But what you said there is interesting, because isn't it impressive when you run into either a federal judge or maybe in any field, I suppose, where, like you said, somebody is a genius, but they're not eggheads, or they don't look like it, or they can relate to everybody in a way that is very common and understandable. I mean, those are among the most successful people that I've encountered.
He thought of himself as a regular guy from Mount Vernon, but when he spoke, it was in perfect paragraphs with all of his thoughts organized. And it's that's kind of how normal people act, Judge.
Yeah. Now, I had a mentor. You remember Bill Meeks?
Yeah. Very bright guy.
Bill was that way too. It's he just had a way of interacting with people that was normal and understandable, but so succinct and on point.
And they think everybody's like them. It's the rest of us are not like that.
No, exactly right. Exactly right. Well, I mean, I don't know if we ever clarified, but here you are. You're locally here in Columbus in our federal court, our Southern District, Eastern Division for the federal court system. When did you land there?
Yeah, so in 2006, I joined the U.S. Attorney's Office in Washington, D.C., and for a couple of years there, I was a felony crimes prosecutor. District of Columbia is very interesting because although you're a federal prosecutor, you're actually enforcing local District of Columbia law. So you're not using the federal rules of procedure or the federal rules of evidence. It's local there.
Interesting.
And so I started off in misdemeanors, doing prostitution cases and drug possession cases. You eventually move up to the grand jury section there, where you're indicting felony drug cases, felons in possession of firearms. And eventually by the time I left, I was in major crimes where you're doing rapes, robberies, even homicides. After a couple of years, an opening came up here in the Southern District of Ohio, U.S. Attorney's Office, and very, very coveted at the time. When I came in and interviewed, they hadn't made a new hire in 6 years. Very small office, and so you don't get a lot of opportunities. And so when that opportunity came up and I interviewed here, that was what the whole plan had been in the first place, was to go to D.C. and maybe get the career started back here. And so I was lucky enough I got hired here in 2008. I started off as a Project Safe Childhood prosecutor, which was child pornography offenses, child exploitation offenses. And for about 4 years I did that until eventually they asked me to move into Organized Crime Drug Enforcement Task Force, OCDETF, which is basically major narcotics cases. And since 2012, that's what I've been doing in the Columbus office and throughout the Southern District of Ohio, which is the lower 48 counties in the state of Ohio. We have federal jurisdiction over any offenses that happen there. And kind of for the last 7.5 years, I've been doing steady diet of narcotics cases.
Well, we're going to unpack a lot of that here as we go along. But even before that, I've done criminal defense for 25 years. I've never been a prosecutor. But one of the questions I get the most is what makes a case federal? Why is my drug case in federal court, or why does a particular case end up in federal court? And I've got an answer for it, but you're the pro, so I thought I would just ask you.
Yeah, sometimes that's not an easy question because there are many federal statutes codified in the United States Code that give a wide range of jurisdiction. Something has to have kind of a federal hook before you have federal jurisdiction over it. But take narcotics, because that's the easiest example. For a case to be federal from a narcotics standpoint, all it has to do is involve narcotics. Kind of both Congress, through the laws they've enacted and through the case law that's come, has said that drugs in and of themselves have an interstate nexus about them. So even as somebody who's growing marijuana in their backyard here in Columbus, that crime has been federalized if you're possessing narcotics. And the whole theory is drugs are inherently interstate because the funds that are going to be purchasing them came across state lines. Typically, narcotics are coming across state lines. In fact, a lot of cases from international borders to get here in the first place. So my answer on a narcotics case is any narcotics case could be a federal case.
Just because.
Just because. The drugs inherently have an interstate nexus to them. Of course, you can't take every federal case. Here in Columbus, we have 22 federal criminal AUSAs, and like I said, we take care of the lower 48 counties. And so then typically offices will set thresholds, and there are more guidelines than anything. Like typically the narcotics cases that I'm looking to take federal involve drugs that we can say came across the U.S. or Canadian border. Drugs where we say there are multiple states involved, large quantities of drugs. Typically a narcotics case that I'm doing is going to involve multiple kilos of narcotics versus street level quantities like ounces and grams. But that's not always a hard or fast rule either, because if you're looking at a target who's bringing in, say, multiple kilograms of cocaine, and you see somebody that's making contact with them and you take that person off in a traffic stop and they have a couple hundred ounces or a couple hundred grams of cocaine on them, that might end up being a federal defendant. They're going to be at the lower level, but in theory you would want to bring that prosecution in hopes that you would flip that person and work your way up the chain.
Right. That's the guy in my office who says, why is my case federal? And my response is, well, because the feds caught you, right? And they're probably looking at whoever gave you that drug.
Yeah, that's typically the answer. And that can be a really unsatisfying answer to a lot of people. And I'll take you back, and I know over the years we had some cases in the child pornography realm. When they started Project Safe Childhood in probably 2006, 2007, it was like we need to do something to combat the fact that the internet is exploding now and child pornography is being distributed. And so we got, DOJ grants of money to hire some more prosecutors. Some more local task forces were set up that got DOJ money. Federal agents were put on those task forces kind of working together. And so you could have the misfortune of being somebody that downloaded child pornography on your computer. An FBI agent is the one who did the investigation. They bring that case to me. You're likely going to go to prison, assuming I can prove it, for multiple years. If that same person was caught by a county officer, they might go over to state court and get a probationary sentence.
Yeah, that's what the differences can be huge, and it's not always that it's worse in federal court. Sometimes it's better in federal court. And we're going to talk a lot more about child porn. Probably in the next segment, I'm going to really pick your brain because I know you did that. You and I worked on lots of those cases, but. A couple of things you said that I think are of interest to me, and that is it wasn't always in our country's history that cases would just go federal because they could. And a lot of times if you were crossing, I guess maybe in our parents' lives, if you went across the state lines, it really meant something, right? You're in you're in a different state, you're in a different governmental entity. And if you got to cross state lines, well, now you're under their jurisdiction.
Sure.
And then I think as time has gone on, the federal power and the federal authority has sort of encompassed more and more and more. Yeah. And maybe even it glues the country together in some way. But the federal criminal code is often parallel. And you could have a bank robbery case in state court, and then people are wondering, why is that not in federal court? Well, lo and behold, it ends up in federal court also. I mean, I've had cases that are prosecuted in both state and federal courts. But I guess my point is that the federal power is growing and has grown, and you're talking about exercising discretion maybe to limit it.
Yeah, I think two things there. One is the fact that I think federal authority just has grown. Congress has made more laws. The criminal codes get thicker every year. So you do have more things where Congress is giving themselves a grant of federal jurisdiction, and the executive branch is running with that. The other thing that's happened is, if you talk about the notion of crossing state lines, well, now everybody has the internet and now everybody has cell phones. And so those devices have been held by the courts to be in and of themselves items that affect interstate commerce. And a lot of times in a federal case, that will be your federal hook. In other words, if you're going to do a bank robbery, the reason that can be a federal crime is because the bank is insured by the FDIC, and so that money necessarily crosses state lines. If you think about a child pornography case, if somebody is downloading child pornography from the internet, they're using a tool of interstate commerce because the internet is inherently a tool of interstate commerce.
Yeah, you're talking, back to your word, you're talking looking for that federal hook because, there's got to be, people take for granted that the federal government has jurisdiction, but they don't always. There has to be some basis for it, even though it's pretty broad. And you said interstate commerce, so Commerce Clause is in the Constitution, and that in theory gives the federal government lots and lots of room to regulate whatever.
Yeah.
But then, like you said, you add in cell phones and all this sort of mass communication network. Anything could be federal if Congress wants to pass a law. Yeah,
absolutely. It's very rare that you've seen the courts strike back at Congress when they have extended federal jurisdiction. There was a case in the 90s where Congress had passed the Violence Against Women Act, and which really was a way to bring federal domestic violence cases into federal court. And that was one where the courts actually struck back and said, this goes way too far. You've exceeded your Commerce Clause authority. You haven't made a sufficient record to say that domestic violence has an effect on interstate commerce. That's kind of one example in the last 25 years where Congress has really kind of had gone a step too far in the eye of the courts. But for the most part, when you say something has to have an effect on interstate commerce, well, did they use a cell phone? Yes. A cell phone is almost always going to be found to be a tool of interstate commerce. And some of the interesting things that you'll think of as like the most serious crimes that you'll see, rapes, homicides. Oftentimes there's not a federal hook to be involved there. Two guys, fight each other in the parking lot and shoot each other. That's not going to be a federal offense unless it's tied to some larger racketeering operation. It's tied to a drug trafficking organization. It's in support of another federal crime. Oftentimes, like the most serious cases that arise in a community, we're not going to have federal jurisdiction over.
Yeah, and maybe that's probably good to point out, because if I have a murder case, and I'm working on several right now, and they're all in state court.
Yeah.
I've never, ever worked on a murder case in federal court. I've testified in one, though. I was a witness in a federal murder case, but I've never actually defended one in federal court because they're so rare. It rarely happens that the federal prosecutors are going to grab a local murder case. I think even if it does have, and let's just face it, most murder cases like that are tied to something. It's a drug ripoff or something. But those typically are state court crimes, and I think for all the reasons you're saying.
Yeah. Typically, a homicide is only going to come into federal court in a couple of contexts. A lot of that can happen if it's in the context of a larger racketeering case, a drug organization that's bringing drugs from out of state and they're killing off their competition. Yeah. That can be a way to bring that in. We've had other cases where federal witnesses have been murdered. That will get you into federal court on a straight-up homicide if you're actually doing that, committing a homicide or any kind of act of violence to kind of suppress federal testimony against you or interfere in a federal case. But for the most part, you're right. The vast, overwhelming majority of rapes, homicides, child molestation acts, those are not going to be in federal court. There's just not a federal hook to bring those in under our jurisdiction.
I got to bring this up. My 15-year-old is taking government, and he was able to point out to me the Commerce Clause, and he knows the case you were talking about. And he goes, "Well, Dad, there was a Commerce Clause case in 1990 whatever," and he even knew that before that we were going really back to the New Deal. I mean, we're going back to the 30s before the court really limited the power under the Commerce Clause. Yeah. That's neither here nor there. It was just sort of interesting that they're teaching that in government, which I thought
it's very rare that the courts are stepping in and curtailing Congress's expansive jurisdiction.
Yep. All right, I got to bring it up because I'm a defense lawyer. You're a prosecutor. I think there's some notion that we should hate each other. But I think often, even my clients sometimes are surprised. They're like, "Oh yeah, I know Michael Hunter. I'll call him." They're like, "What do you mean know him?" I said, "Listen, we've worked together. We have a professional relationship, a working relationship. In a lot of ways, that makes it work better."
Yeah.
What are your thoughts on? What are your thoughts on the defense bar, and how do you guys relate to us, the bad guys?
Yeah. What I always say is, I have a luxurious practice of law, and what I mean by that is this. Most of the time when I decide to pull the trigger and indict somebody, arrest somebody, there's been a long-term investigation, so I've kind of got all the evidence that I think I need at that point. It doesn't make me a great card player, but I'm usually holding 3 aces in a case. So there's just not typically a reason to have a real contentious relationship. One, it would just make me a jerk if I was lording that over everybody how great my case was. I'm not a jerk inherently. Second, there's no reason for you to come in breathing fire at me and talking about what I've done to your client when it's like, well, there's surveillance, there's search warrants, and he was Mirandized and he made admissions. So in most of the cases that I have, there just isn't a reason to get real contentious. If we have cases where there are going to be issues that we're going to fight about, normally, like the relationship we have with the defense bars, we'll agree where we're going to disagree. And there just isn't any benefit if you're going to have to come back to me and have cases that I'm going to prosecute for us to have an acrimonious relationship. I'm going to be here for a while. You're going to see me again. There's really no reason to throw down about this one case. And I can tell you it's not going to go well in front of a U.S. District Court judge with 2 lawyers squabbling back and forth anyway.
Yeah, they at least here, they don't accept that. I mean, they're not going to let that go down very long at all.
And so to me, there's a lot of reasons why it just doesn't make sense to be acrimonious all the time about things. If I'm doing my job right, I should be bringing cases where defense attorneys are mostly going to be working in mitigation mode. It's not a question of guilt or innocence. It's a question of how much time somebody's going to get. And then, and I know this is going to sound corny, but what we are really counseled and what our objective is as a Department of Justice is just that. It's not just to win and get the most, number of days in prison you can get for somebody. It's to find a just result. And most of the time, for people that aren't familiar with how the federal sentencing guidelines work, somebody commits a crime, assuming you can convict them of it, that crime gets assigned a score. The higher the score, the more prison time you get. If you accept responsibility, those numbers come down. If you ever agree to cooperate for the government, I have the ability to file a motion on your behalf that would lower that. So most of the time, if I've done my job right, it's a strong case. People are incentivized to come in and accept responsibility and cooperate. Well, if you're doing that, then there's no real reason to be acrimonious about that.
Sure. And I guess on some level, then somebody might ask, well, why isn't it like that? Why isn't it like that everywhere? So in state court. And my dad, who actually was a United States attorney for a stint, used to say this. He goes, we get to choose and pick cases we like, which really means they get to have all the evidence, like you're saying. It's like he wasn't going to take, and I imagine you guys aren't going to take crappy cases. You're not going to take cases where either somebody's dropped the ball or the evidence isn't strong or you can't make it. And it's certainly not intentionally you're going to bring a case like that into a courtroom because it doesn't do anybody any good. State court doesn't have that luxury. They have to take cases. I mean, everything gets filed in state court, and that's just what it is.
I agree 100%. And I mean this to all my state court prosecutor friends. They have a harder job than I have. They deal with that crush of cases that comes in every day. I promise you, the police department, the sheriff's department were out last night, and they probably arrested several dozen people on a given night around here. Those cases are going to come in. They're going to get assigned to people. You might have to prosecute that case. Sometimes those cases are inherently defensible. A purse snatching where a woman says, somebody punched me in the face, grabbed my purse, ran around the corner. The cops stop a guy a block away. He's breathing heavy. He's got something on him, some money that may have come out of that person. The purse has been discarded. The woman says, that's the guy who punched me. That's all that case is ever going to be. There's not going to be CSI coming and swooping down. There's not going to be video footage. That's a defensible case. How are you sure enough about her identification to convict that person beyond a reasonable doubt? That's a tough case. Those are the kind of cases that state prosecutors have to charge and then prosecute all the time. I'd almost never have to do that scenario.
Yeah, and they don't have a choice. I mean,
they don't.
That's their job, is to prosecute cases that they might lose.
And you can also see from the defense point of view on that, really, my God, you didn't catch him with the purse. It's one witness who's identifying him. This lady is 80 years old. How can you be so sure about the identification? That could be a much more contentious situation than if I turn over to you, Steve, here's my 3 weeks worth of surveillance of your guy who's 2 controlled buys of narcotics we've done from him. Here's the search warrant we executed where we found drugs. And by the way, we interviewed him. Here's the Miranda form, and he confessed. You're probably not going to be breathing fire at me about that.
At least I hope not. Well, look, we're going to take a quick break, and when we come back, I want to follow up a little bit with some of the stuff you talked about, particularly child pornography and some of the narcotics cases that and the trends we're seeing. So we'll be back in a minute. All right, back from the break. We covered a whole bunch of ground, and I'm going to get back to it. But obviously, you're still working at the United States Attorney's Office. You're here talking right now. I mean, you said you want to make a little disclaimer.
I just would like to say that the opinions that I express here are mine and not necessarily those of the Department of Justice.
Well, so far I agree with all of them, so we can rock and roll with it. I wanted to point something out. During the break we were just talking about this, that I have been to many seminars around the country. I have talked to many of my brethren, so to speak, in the criminal defense bar. And I am shocked to hear how they have it in their local federal courts. I mean, my perception of our federal court system, you included in your office, is that it is, look, it's not always great because usually my clients have a big problem to deal with. But from a professionalism standpoint and just workability, we don't have the problems here that others do. And I don't know why that is. I don't know if it's because there's a different demeanor. I don't know if it's just because Columbus is lucky. I have no idea. But some of the stuff you're talking about with sharing charging decisions and why you're deciding to prosecute a case with a defense bar, I think goes a long way to extend that olive branch to get cases resolved or litigated if that's what needs to happen.
Yeah.
And the attitude that you guys have about that, just for whatever it's worth, makes our job a lot easier and a lot better. But
I think it's multifaceted why I think we have a good thing going here in Columbus. I agree with you 100%. I think U.S. District Court is a great place to practice. I think it starts with the bench that we have. I think we have a really great bench in the Southern District of Ohio. And I'm not just saying that, because they might see this someday. I think the judges are fair. I think they're trying to get it right. I think that they tend to really stay out of the lawyer's way and let us litigate our cases. It's not uncommon that if both parties are saying, hey, judge, we need a continuance, you don't get a lot of pushback on those things. They tend to give us a lot of, pretty good wide berth on that. I feel that most of the judges, in fact, all the judges over there are sensible. They're fairly middle of the road on sentencing. Every judge will have different sensibilities about some particular issue, a child pornography case, a drug case. But so they kind of set that standard of, it's going to be very normal in that courthouse. You're not going to walk into a courthouse over there and get shocked by a sentence or something that happened in a courtroom, generally speaking. And then I can't say this enough, like our office, the Department of Justice really does talk a lot. And it's not just talk, we mean it, that we're trying to get a just result. And so you're not going to see us pursuing things at the outer realm where, if we're going to do a case where it's a racketeering case, it's going to be something like the Short North Posse, where we're going to have spent years building that case, so that we have, both the trust of the public, the trust of the court, and the defense attorneys are going to come in and not be like, well, you guys are just conducting a witch hunt, because that's the kind of thing that leads to an acrimonious area. I think we've also benefited by having a really good defense bar. I think in U.S. District Court, they have the Criminal Justice Act where they provide a panel, where they'll hire local attorneys will be on that list to represent people in a federal court. I think the judges over there do a really good job of keeping good attorneys on there, people that have good relationships, people that aren't. It's not a firebrand discussion every time they come in for a case. So I think that is done well. We've had the benefit of very good public defenders over the last 20 years. Steve Nolder, I think, is just absolutely one of the best lawyers you're ever going to meet.
He just set the mark of how we should behave over in that court system.
He really did. And then so you end up just kind of with a culture over there that is more collegial. Not that we don't have to argue about things, and not that we don't have to fight. And certainly when you have a trial over there, that can be contentious at times because things are in dispute. But for the most part, I just feel like everything, both from the defense bar, the bench, and from our office, has pointed to, let's be reasonable. Let's figure out a way to get this done in a way that makes sense, to get a just result here. And I think that also our office does a pretty good job of, we're not adamant in stomping our feet up and down in federal court about demanding a particular sentence. We make recommendations to the court. We'll make our arguments in support of that. It's been, I think, in my 12 years here in Columbus, I think one time we've appealed a sentence from a district court judge. Generally speaking, we try to be very deferential to the court, make our arguments, and recognize that the district court judges have a ton of discretion on these things. And when I talk to young lawyers all the time, one of the things I tell them is you have to recognize how much discretion a trial court judge, whether it's a district court judge, a state court judge, a municipal judge, has. And so you can't be waving your fist about what the law really says and all that. Instead, figure out a way to be persuasive and win that argument in front of them, because the romantic notion of you're going to take somebody to the Court of Appeals and get a conviction or a sentence reversed, it just doesn't bear itself out when you actually practice law.
No, not statistically or in any way for that matter. Yeah. And you hit on something I think is interesting, is that we have this, in society right now, people hate each other on different sides of the political spectrum. And maybe there's a cue that could be taken here, right? Because we go in on completely different sides of a case. And like you said, sometimes battling out in a courtroom where it's heated, where it matters, where there's a lot at stake, but then people can still shake hands and go to lunch or talk like this later on. And there's a civility to the disagreement that is very effective, I think, more effective than screaming at each other, in fact.
Yeah.
And our court system has fostered that. But I want to talk about drug cases for a second, because there's been a big change in the drug laws. I haven't represented somebody on a federal marijuana conspiracy now in years, I would say. Sure. What's that on your perspective? What's the marijuana legalization push doing to you guys? Yeah,
it hasn't changed federal law at all. We've always had the point of view here for the U.S. Attorney's Office in the Southern District of Ohio that a marijuana case would have to be pretty exceptional before we're going to take it into federal court. And by exceptional, I think the last I can't remember doing a marijuana case in my career that was less than 100 kilos. And that triggers a mandatory minimum of 5 years. I've done marijuana cases where the relevant conduct was 10,000 kilos of marijuana. So there just aren't that many of those cases now that I think because marijuana is legal in the United States, not in those quantities. I don't think it's ever going to be legal to own 400 kilos of marijuana. But because you can get it more easily now, I think the days of having large-scale amounts where somebody's bringing in hundreds of kilos of marijuana a month into Columbus, I think those days are over if it's going on out there. I don't know about it right now. Every once in a while, you'll get a drug case that has some component of that. But I think that, the changing landscape with marijuana, even though it hasn't changed from a federal legal perspective, is like the reality is we're not seeing those type of cases anymore.
Yeah, and you guys, I mean, you're talking these big numbers because you're talking about prosecuting the suppliers. You're talking about like the not even the wholesalers, but like the wholesalers, like people bring it into the country.
If we had a marijuana case, I would want to, however that marijuana got here locally, you would want to work it back to the supply, and that's almost always going to be out west or in Mexico.
And it is, as a corollary to that, it's not that you were prosecuting before the local users. So that part hasn't shifted. But if the local users are getting it some other way legally, then the demand for that big supply isn't there. I think that's what you're saying.
I think that's right, yeah.
All right. Well, it's not like you guys aren't prosecuting drug cases. What's next and why?
Yeah, I mean, obviously, one of the stories of the last 5 years, it would be the fentanyl problem, opioid problems that we've had in general. And fentanyl is so much more prevalent on the street now than it was 5 years ago. Methamphetamine is making a comeback in a big way. I can remember probably 6 years ago where we caught somebody with 5 kilos of methamphetamine, and I was stunned. Like, we haven't seen that much methamphetamine. We actually had to call down to Atlanta and be like, what's a kilo of methamphetamine worth these days? Now it's commonplace to get traffic stops with 5 or 10 kilos of methamphetamine. For a couple of years there, car fentanyl was on the streets, which is, it's literally 100 times more potent than even fentanyl. And it was causing so much of the overdose deaths and just carnage that we generally have seen. I think there's a lot of social science and criminological evidence out there that some of this has happened through kind of the doctrine of unintended consequences. And it'll take me a minute to tell this story, but I think this is borne out by what we've seen, and that is, some of the states that have legalized marijuana, both outright and just medical marijuana licenses, it's incentivized or allowed for people to grow their own marijuana quite frequently in the United States. Well, up until that time, it had been almost entirely illicit activity, and a lot of that was cartel-driven, whether it was funding grows here in the United States or drugs that were coming across the border from Mexico. Well, when all of that profit margin went away for cartels, what you saw is them turning to other substances that they could produce more cheaply.
The cartels weren't cool with just losing billions of dollars in illegal drug trade money?
Apparently not. And so what you then saw was a ramping up of the production of methamphetamine. I can remember narcotics cases I've done where we would find 10 kilos of methamphetamine in a suitcase in a house, and you hear the story once and you don't believe it, but you hear it multiple times, like, I didn't ask for this. I sell cocaine. They just sent it to me and said they've got so much of it, just try to get rid of it if I can. And suddenly you're seeing massive quantities of methamphetamine. And then the same thing has happened with fentanyl. It's synthetic. It's easy to produce. It's very cheap. The profit margins are high. I think there's a lot of, like I said, criminological, sociological evidence, social science evidence that shows that some of the advent of opioids really entering, and fentanyl in particular, and methamphetamine coming back in a big way is an unintended consequence of the fact that marijuana legalization has happened. And
that in that conglomerate is heroin, right? I mean, so when you're talking about opioids, heroin and all those drugs are back. But there's more. I mean, I've represented a lot of physicians over the years. There was a time frame when I represented a lot more physicians, and it seems like there was a little bit of a push to prosecute the pill mills, to prosecute those who were prescribing Percocets or Oxys or whatever it was. And then you guys, by you guys, I mean the government sort of said, we're gonna prosecute those individuals. And what's your take on that?
Yeah, I think, there was certainly a time when I think everybody was in agreement, like pills were a tremendous problem. Like people were just abusing pills. You were buying Oxycontins for a certain amount and then tripling by the profit by selling them on the street. And so pharmaceutical companies were certainly mass producing opioids. I think I saw a statistic where the United States is 5% of the world's population. We consume 75% of the prescription narcotics, opioid narcotics. And so we did make a concerted effort to prosecute some of the pill mills. I'm just making up names here, but a small town in southern Ohio where they've sold 10 million, pills to a populace of 1,000 people.
Sure.
Something doesn't make sense there. Targeting some of those for prosecution, and we were very successful. We probably shut down, I'm going to say, at least 10 pill mills in southern Ohio in the last few years. Doctrine of unintended consequences. A lot of those people that had been abusing prescription drugs simply switched over to heroin, which was readily available and much cheaper. There's a really great book by Sam Quinones about Portsmouth, Ohio. It's called Dreamland.
Yeah.
And it really just documents that's exactly how that went once the prescription pills dried up because of prosecutions and just doctors seeing the risk in getting out of the kind of the pill pushing business, that you had people that were ready to capitalize on it with a business model of selling heroin. So as you crack down on heroin and start doing things like that, the cartels, drug traffickers figure out where the next profit point is, and that was fentanyl. And for a while, carfentanil, it was very easy to produce. It started coming across. It's much smaller quantities to get that same kind of a high. Sat down with many drug traffickers who agreed to cooperate, and what you would hear from narcotics users would be the fact that somebody's been on heroin for several years, a user, like at the street level user, and they're no longer kind of getting that same high anymore. When fentanyl came on the street, they called it fire. Like suddenly a very small amount of that, and you're not just using the drug to maintain yourself anymore, you're actually getting that high off of it that kind of got you addicted in the first place. And so despite the fact that you're seeing all of the deaths, if you pick up a newspaper over the last 5 years, watch an evening newscast, fentanyl and carfentanil are killing people. Still an insatiable demand for it on the streets. So those people, in a lot of instances, went from prescription drugs to heroin to fentanyl.
Well, and I'm gonna turn back the clock, because what you've said is, all right, we started cracking down on the pill mills, which, and by the way, it was out of control, right? I mean, it wasn't that was a bad thing. I mean, there were, like you said, the number of pills.
We were reactive, but that was a real problem to react to.
And because of that, people were sort of on the streets getting their drugs elsewhere. But even before the pill mills, I remember talking to physicians who were getting prosecuted, and they're like, well, look, 5 years ago, the American Medical Association is pushing us to treat pain. I mean, it's almost like we created the pain clinics, and that was based on some policies that we should take care of those who need it, right? We should really promote a medical practice for those who are in constant pain and need the therapy and treatment. Well, that led to this pill mill concept. Yeah. And then all of a sudden the AMA gets involved and says, this is bad, you can't do it. And all these doctors are looking at me, my clients, saying, they told me to do this, and now here we are. And again, it got out of control. So it's like, it was a little bit out of control. But it's funny how one policy here sort of has this snowball effect, or this domino effect rather, to create another problem. But I don't think it's fair to say you shouldn't have done it, or that we shouldn't stop that stuff. It's sort of a cat and mouse game, I suppose.
Yeah, I'll tell you, the things that you learn, and you get better at doing these things, and that is we've done some, fairly recent prosecution of pain clinics, what I would call pill mills. And one of the things that we put in place when we did the takedowns were kind of mobile centers. Like, okay, well, these people if we're taking out their supplier of something they're addicted to, they're going to go someplace. And instead of just like, oh, well, that's your problem, narcotics user, actually having treatment facilities available. This is an opportunity to get people that are going to show up to that doctor that you just took down, get them into treatment, and kind of recognize, like, you move the problem around in some instances. And so I think we've gotten a lot smarter about how to do it. But again, having the best intentions and responding to a problem, sometimes you end up having a hand in creating another problem.
Yeah, and that'll sort of lead to my next question for you, is that, or observation, I want to get your comments, is that I remember back in, I don't know, the late 90s, or even into the early 2000s, I suppose, I did a ton of dope work. I mean, it just seems like there was a task force in every place that to go enforce drug work. And then that sort of fell off after the war on terror begins. And as I look back on that, it dawned on me recently, it's like, all right, well, of course, I remember talking to task force officers, and I was like, what are you guys doing out there? It's like, wow, it's all, we're all on terror now. All the FBI is allocated over there instead of here. And I think it's sort of eye-opening to me to understand and recognize that you guys have a finite resource. By you guys, meaning I'm giving you the federal government, but the federal government has a finite resource. It's not like we can just add more agents to take on whatever it is we want to take on. It is like we're going to take them from here and put them over here. And that has I see that impact almost directly on what comes in my door. And I'm sure you do on what you're indicting and what the crimes are.
Yeah, I think the federal government, U.S. Attorney's offices being part of it, are inherently reactive. There's the old cliche, the most generals are fighting the last war. When we see there's a problem, by the time that we do things like form task forces and all of that, a lot of times you're allocating resources to something that may be dwindling, or you're being reactive, and by taking those resources and moving them at something else, you can't be prospective about what's coming down the pike, what might the next problem be. So I think you're always going to be kind of inherently reactive. Every administration has their own priorities. Some of that's philosophical. Some of it is in reaction to, the worldview of what they're seeing. But a really great example would be, about 2008, 2009, we started a mortgage fraud task force. People remember like the housing bubble burst and
kept me busy.
Yes, all the mortgage companies and all that. Well, when you do that, then you're setting that as a priority, and you're going to put time and resources into that. Necessarily those resources aren't going to be doing other things, and so that can be a time when another area of crime flourishes because you have your resources pointed in one direction, and then another administration will come in and they might have a different point of view on that. Again, I always think everybody has the best of intentions, and there's never been anything in my 13 years with the Department of Justice where I've been like, well, it's crazy that we're spending time on this. It's always in response to a real problem, something that constituencies are complaining about. But it is a little bit of a zero-sum game in that once you take resources and aim them at one particular ill, it leaves an opening for that to flourish again. And so in a way, it feels very circular, like you'll be coming back around to narcotics will then again be a problem, or violent crime is now a problem. And so, Dave DeVillers just took the helm as the U.S. Attorney here in the Southern District of Ohio, and he's here in Columbus. His priorities are for us to do impactful cases, and with a focus on violent crime and maybe child exploitation, things like that. A perfectly reasonable point of view on that.
Sure.
We'll see, as our office, changes direction a little bit. I'm sure that in a few years there'll be another area that has, kind of flourished that we're going to have to turn our attention back to, or maybe something new that we never thought of is going to come up. Like, we're kind of always in that circle.
Well, it's time for another break. When we come back, there's a couple areas I want to talk to you. I want to talk to you about plea bargaining and that decision making and what goes into that, not only from your perspective, but my side too. And then I want to spend some time talking about child pornography and some of the issues that Dave DeVillers is going to be looking at going forward, and get your thoughts on that. So we'll be back. All right, back from the break. I promised all sorts of stuff, but I'm going to get into another topic here. I'm going to talk to you about plea bargaining and maybe even a broader topic of racism. I hate to use those nasty words here, but look, it is the criminal justice system. I've done criminal defense work for a long, long time. You've prosecuted for a long, long time, and there's this notion that perhaps baked into that is some nefarious motive and outcomes. And I think I'll just take it on, and I'll sort of pick your brain about it. I shared with you I had a dinner party in a neighborhood recently. I had somebody ask me, and it was almost like it was they were telling me, I'm sure, Steve, you've seen a lot of racism in your practice doing criminal defense. And I might have surprised them a little bit when I said, well, look, no, not really. I can't say that there hasn't been a police stop of a car at some point based on race. I can't say that it hasn't, or it has or hasn't happened. I'm sure it does on some level. But if I had to pinpoint it, it is significantly less than I think the narrative people sometimes like. And why don't we just air that out for a minute? You're the government prosecuting cases. What's your take on it?
Yeah, I think it's a really important thing to talk about, and I would just love for the public to actually, know more about the process. Because I would say it this way: I don't know that there has never been any racial animus underlying a case that I've done. I can say that I've never seen any evidence on its face that's ever risen to the level where I'm like, this is problematic. I've just never seen that in all my years of doing cases. And I think in part, the reason why is because of the process that goes into the prosecution of a case, and by the time you actually get to the point of sentencing somebody. And bear with me for just a minute. Like, if you think about like how, and I'll just use a narcotics case, I think it's an easy example. You're going to have and let's just deal with a traffic stop. You're going to have a traffic stop. Well, that traffic stop is going to have to be reviewed. If a police officer makes a traffic stop, it's going to have to be reviewed and justified to a shift supervisor before that arrest is going to be able to be processed. It's then going to have to get presented to a prosecutor, who's then going to have an opportunity to review that case and decide, is there a reason to take this case? Is there some reason why we shouldn't take this case? And believe me, a reason not to take a case is because you think it's based on race. The prosecutor is then...
And let me interrupt you. That would be true even if it's otherwise a good case. I mean, I presume that's what you're saying. It's like if you looking at a case and say, this is really fishy.
Yeah.
We do not want to have
The justification of this traffic stop doesn't make any sense to me. It's a white officer involved, car full of blacks. This does not, and I'm not buying your reason for the traffic stop. That would be things that would set my spider sense off, for sure. I would ask a lot more questions about that. But, if me as a line prosecutor wants to take that case in, I'm going to have to present that case to one of my supervisors, and they're going to have to sign off on that case. Then the defendant, if we make the decision, ultimately this is a meritorious case, we're going to bring it in and arrest that person, they're going to be pulled in front of a magistrate who's going to review the affidavits, who's going to review the case. Then they're going to get assigned defense counsel, somebody to look out for their interests. We're going to have to then turn over all of our discovery, the police reports, the affidavits, everything underneath this case. So now you've got somebody who's looking out for the defendant's interests at this point, other than just this vague concept of justice and due process, actually looking out for the defendant's interests. As the case goes along, let's assume that we're going to talk about resolving the case. I'm going to have to convince the defense attorney that this case has merit, there are no suppressible issues here that you're going to bring, and that the sentence is going to be fair that we're going to ultimately seek in this. Even once we do that, the case and somebody agrees to plead guilty, you have to stand in front of a district court judge or a federal magistrate to take the plea and show them there's a factual basis for this plea. This person has been advised of all their rights. They understand their ability to make all these motions. They understand the rights they're giving up by pleading guilty. Once you've gone through all that, then let's assume somebody has pled guilty. You've already been through a lot of redundancy and levels of people that have had to sign off on it. Then in the federal system, it gets assigned to a probation officer who then does a thorough background investigation of the defendant and takes into account all of their history, not just their criminal history, their life story, their background, their family, their education, their circumstances. You've seen these reports, they're 40 or 50 pages, and it's really like, this is your life for this defendant.
Sure, yeah.
Once that comes, that copy goes to the prosecution and the defense. We both get to review it, decide to make any corrections, any objections that we have to anything that's being considered. That report then goes to the court. And ultimately, at the end of the day, we're going to stand in front of a district court judge who's got a lifetime appointment, and they're going to have another chance to review this case. Has what's gone on in that case passed constitutional muster? Are there any reasons why this case shouldn't have been brought in the first place? Is there something about this case that this defendant is facing too much time? Is there some, due process reason why this case shouldn't be proceeding? And then ultimately that judge is the person who's going to make a decision on what the ultimate sentence is in this case. Now, can I prove to you that somewhere along the line that somebody in that process didn't have a racial animus or a bad motivation? No, I don't think I can ever prove that. But I would just say to anybody, what process more comprehensively could be set up to try to ferret that out than the system that we have?
No, for sure. And I think if I'm looking at this from a sort of our inside-out vantage point, I would never be able to say that there hasn't been a police stop based on somebody's race. In fact, I'm sure it happens. But then that sets a chain of events, and it would have to involve everybody if that prosecution continued. And I guess what I'm saying on my end is I typically do not feel or see or have any reason to think that my client, and I've represented I'm indiscriminate, I don't care, and it makes no difference to me, but I've not seen one treated differently than the other for reasons that I think are race-based. Now, that does not mean perhaps, if somebody's going to make an argument, then there's probably a better argument of some sort of unintended impact, or like you were saying, unintended consequences.
Sure.
So if you're going to say we are targeting Mexico right now because we're going after heroin, well, we're going after heroin. Now, is that targeting where it's coming from? Yes, it is on some level. So that's going to have an impact on that group of folks.
Yeah.
But maybe not from a racial intent, I suppose.
Sure.
That would be a very reasonable position to have. But I guess by and large, people think that there's something there that maybe is not there, and certainly not for the reasons they might suspect. Which leads to the next question I got, which is, well, in plea bargaining, everybody's plea bargaining. Now this one hits home to me because I have my mentor, we've already talked about Bill Meeks. He tells this story about his mentor, a guy named Paul Cassidy. And Bill Meeks has passed away. And when I went through some of the stuff that was left behind here in the office, I found a video of Bill talking at Paul's service over at the courthouse, county courthouse. And I'll try to summarize this quickly for brevity, but he basically said, yeah, he watched Paul dealing with a client. He said, Paul's like, why'd you come in here? Oh, because I want the best. I'm not the best. Well, I wanted the best trial lawyer. Probably not the best trial lawyer. I wanted the smartest jurisprudence guy. That's probably not me either. Well, what are you? He goes, look, results. I want results. I want my clients to get the best result they can get.
Sure.
I want my clients to win if they can. I want my clients to get the minimal consequence if they're guilty and no consequence if they're not. And all of those things that we have this perception of what I do for a living have to go into the perception of what I do for a living is I should go fight. I should have a trial. And I would just ask anybody if they would go fight Mike Tyson in the streets. It's like I wouldn't, because I would lose. And like you said, in federal court, if there is a case that you guys bring, you're not bringing it because you think it's crappy. In fact, the opposite. Now, I'm not telling you, and you know me, I've worked with you enough, I'm going to look at it. And if I got a problem, I'll go fight it in federal court. I don't care where I am.
Sure.
But it's a surgical decision or a calculated decision, not one based upon pounding the table and doing it for the cause, because, as my mentor said, we represent clients. I represent people, and they want results. They don't care for the cause, or at least my experience is you don't care for the cause if you're looking at 20 years in prison. And that impacts my decision to plea bargain. So to circle this back, it's like I engage in plea bargaining all the time, and it's not a bad thing.
Right.
In fact, often it's a good thing. What's your perspective on it?
Yeah, I think that, the vast majority of the time, again, if I'm doing my job right on the front end, you're going to see that we're bringing a case that's very strong from an evidentiary standpoint. That's maybe not a triable case, not a case that you're going to win. If somebody has admissions and undercover officers that were recorded making control buys of narcotics, like it's a very difficult case to defend. And so we're really not even talking about guilt or innocence at that point if we're talking about what should the sentence be. And then I think that I think that our office strives to be very reasonable. I think that the federal system is set up to reward people who are going to accept responsibility, ultimately agree to cooperate with the government, to resolve cases pre-indictment. I think that the whole system is set up to incentivize that, because if you have two similarly situated people, one is, and let's assume for the sake of my argument, overwhelming evidence, and one person is going to immediately say, you caught me, I want to put this behind me, I want to accept responsibility. In fact, I'll even sit down with the government and cooperate, and I want to resolve this case at the earliest level. If there's going to be a lower sentence, it's probably going to be for that person, and again, in the face of overwhelming evidence, rather than the person who's saying, no, I'm going to litigate everything, I'm going to file every motion that I can, I want every hearing, I'm going to make you indict this case, and I'm taking this to the box. I want a full trial, despite the fact that the evidence is overwhelming. Just from a common sense standpoint, it would seem the person who's accepted responsibility and tried to move on is going to get a better deal. That's really almost always, in the absence of an incredible criminal record, gun specifications, things that just don't happen very often, it's almost always going to work out that way, that person is going to get a better sentence, just pragmatically and just the way that the federal guidelines work out. There are some instances where there's no good answers. Back in the days when I was doing child pornography cases, if somebody actually made a video that qualified as child pornography, either of a sexually explicit video of a child or of them actually performing a sex act with a child, it was a mandatory minimum 15 years. I have no discretion on what the sentence is going to be. I can't say, 10 sounds about right. There are some offenses that are charged where you may have to litigate that case. You may have to do everything in that spec. But the vast majority of the time, we have enough discretion and the system is set up that somebody resolving a case, I can take that into account as far as what plea offer I would make in the first place, and I can definitely take that into account for the sentencing guidelines. The difference between me saying that somebody should receive a sentence, assuming the judge listens to me, at the lowest end of the guideline versus the highest end, that could be several years of prison right there.
Sure.
And so a lot of instances, it always helps, I'm sure you would agree if you're the defense attorney, when you are saying, my client made a mistake, they put it behind them, they've done everything that the government asked, and all I'm doing is standing there nodding my head along. That helps in front of a judge.
Absolutely. Now, let me give you the other side and get your comments on, or get your thoughts on this. So if plea bargaining, I would posit this. Plea bargaining in and of itself is not a bad thing. I mean, in fact, the system would bog down and almost die if every case went to trial. And I think there's some cause-oriented folks out there that say that'd be a great thing, and maybe so for reasons we don't need to get into. But if I am plea bargaining a case, it's either because the evidence is overwhelming, and that makes perfect sense. But here's where here's where I want to get your thoughts on it, because sometimes I have to plea bargain what might be a halfway decent defense, because if I lose, the consequences are astronomical. Now, the irony of this is we're sort of back to these unintended consequences, because the same people on either, I don't care, it's not politically oriented at all, the same people who might have a cause to say we're going to be hard on crime, so we're going to make the consequences of being convicted of this particular offense 20 years or 10 years mandatory.
Sure.
If I've got a case that maybe is a roll of the dice at a jury trial scenario, or I can take a plea bargain where my client will get 2 years and maybe out, or a year and a day and maybe out in 6 months, well, I'm taking it, right? And not without good reason. Now, if there is no mandatory minimum and I have a good case, that might actually create more trials. And I think I know your answer to this already, and I know what my answer would be. But if plea bargains are encouraged, it's because of some of the policy that is getting driven down from Congress on sentencing, that handcuffs you, handcuffs me, and by and large handcuffs judges to say you have to do this if there's a conviction. That probably results in more plea bargaining on my end anyway than anything else.
Yeah, I think we try to be very responsible in how we use the tools that Congress has given us, and especially I'll talk the drug realm, but it's also true in the child porn realm. You have charges where there are mandatory minimum times. In other words, if I charge somebody with more than 1 kilo of heroin, in theory is 10 to life, so a mandatory minimum 10 years. There could be a way that I would charge that so that I could charge that as only a 5-year mandatory minimum, the same quantity of drugs. And those are decisions that we make on a case-by-case basis, and I've always said that I think we should absolutely be explaining to the public why we're making the charging decisions that we're making. They have to have confidence that we're not just trying to max everybody out, that we're actually trying to be reasonable about that. But again, I think this is some of the virtue of the federal system is in the scenario that I just gave, person with a kilo of heroin, mandatory minimum 10 years. In theory, everybody's hands are tied. It's actually not true, because in that instance, if they don't have any criminal record, they will qualify for a statutory and guideline provision called the safety valve, which allows that floor to be removed and for a judge to go lower. If that person wants to come to the table and cooperate, and typically that entails sitting down and agreeing to provide information to the government and testify if ever needed. Doesn't happen very often, but occasionally it does. Again, that's another avenue for me to file a motion that would then relieve that statutory minimum. So in the vast majority of narcotics cases, probably 80%, you're going to have people that have cooperated because it's in their interest in doing it. It's incentivized by the process, and it's in people's interests. And when I hear people have a discussion that, everybody should take everything to trial and shut down the criminal justice system, it's so fundamentally at odds with the role of being an advocate for that particular person. This is a real person. They're going to really do that time. Sometimes the best thing you can do for somebody is you have to plead guilty and get on board with the government. Otherwise, you're going to go to prison for decades. It should never be an ideological matter, both why you prosecute a crime or the way you defend it, about you're trying to make some larger principle. You're talking about individuals. It's an individual case, and these are individuals' lives in your hands, and you're a defense attorney. So I bristle when I hear people say we should shut down the system by taking things to trial. Well, what if in taking something to trial, you have cost that person a decade of their life in prison, that there was an offer on the table that you could have taken, your job is to advocate for that person. And a lot of times it's not very romantic. It's not, the Atticus Finch view of being a lawyer. Oh, sure, sometimes the best thing that you can do is tell somebody the best thing for you to do is plead guilty, cooperate, and throw yourself on the mercy of the court. Because if you don't, the evidence is stacked up so that this could cost you decades of your life in prison.
Well, you've hit on a couple of things that are really important, and it goes back to my theory of what I do, right? I'm about getting results for a person, an individual, a real person, a real individual who is sitting in my office, people that I get to know very intimately. And I hear this all the time. How do you represent those dirtballs, or why would you do that for a living? Well, when they're sitting in my office, they don't ask that question. When people sit there, they want help and they need guidance. And if I represented causes instead of people, I would be doing them a gross disservice. I think a malpractice disservice, because if I am going to go to court, have a trial for a cause in a case that I can't win, then irrespective of whether I agree with what the law is, how long the statutory punishment ought to be, or what your position is on the government side, I have a set of facts and circumstances I got to deal with. And if I did that and my person, my client, my individual, somebody's family member, somebody's wife or husband is sitting in prison for a decade, and it could have been 8 months, well, that's not a result. That's a travesty.
Yeah.
And I think a lot of people, we're back to this unintended consequences notion. A lot of people do what I do, lose sight of that. And it's troubling to me, because if I lose sight of that and I say, well, this is a bunch of garbage, we're going to fight the man, or we're going to take this on, your client better be on board with that. Yeah. And if they're not, then you're not doing your job. I'm not doing my job correctly. Now, that doesn't mean I can't go lobby to change the rules on mandatory sentencing. It doesn't mean I shouldn't be behind all that, and I am in a lot of ways. But prisons aren't always just full of people because of they plea bargained or whatever. I mean, if we talked about this other notion too, it's like almost always there's a consequence, or there's a multitude of factors that result in a consequence. Yeah. And you've already brought it up in a narcotics case, for instance. I mean, you might have somebody who's got no prior record. It's their first time in a courtroom, let alone a federal courtroom. They've done everything else very well their entire lives, versus somebody else who's got a prior record, been in court many times, doesn't even hold down a job. Well, the first individual ends up going to prison. Well, if I added one more fact, like this guy cooperated and brought down a drug cartel and this guy didn't, well, that sort of makes sense. But if you leave that fact out, there's a disparate impact there. Yeah. So I guess it's important for me, and maybe us, and during this conversation, to at least point out that there's a lot that goes into this. Yeah. That transcends your agenda, my agenda, and really, for me, goes right to the heart of the matter, which is what is best for my client.
And I'll tell you, like my office here in Columbus and the lawyers that I've worked with for over a decade now, I do think we do a good job, and we talk about it actively, of that these are real people, and it's not just a number. And when I go to court and I make the arguments that the guideline range is 78 to 96 months, it doesn't matter to me whether it's 96 or 78 or a judge goes lower. It really shouldn't. It's about making the argument, playing your role in the process, and you shouldn't go in there and argue because a better sentence looks better for you. That's just not. It's just not how we think about it. These are real people. These are real lives. I've sent hundreds of people to prison. It's a great responsibility, and you have to exercise that. You have a lot of power, and I think I take very seriously my reputation. I hope that my reputation with the defense bar is that I'm fair. And if you're fair, and I say this to defense attorneys, I probably said it to you in one of our cases over the years, like what I want to have is after you and I have had a case together and it's been resolved, whether it had to be, we had to have a suppression hearing that you won, a trial that you won, or vice versa, I want you to be able to say to your next client, if you come in and you act fairly with Mike Hunter, he will treat you fairly. Because if I ever lose sight of that, then the next time you have a client, you're going to be like, I don't know that we can make a deal with this prosecutor. He's not going to keep his word, or he's going to go in there and try to max you out. The system doesn't work also if you're not fair and reasonable from the prosecution standpoint. And I mean this because a lot of time we're holding all of the cards in a case.
Well, and you are fair. I've always felt that with you, and virtually everybody I've dealt with in this office. And the inverse is true. I always say this, that I hate lawyers, right? I mean, I've said that for years. And I love the legal education. I love the philosophical viewpoint of it. But I hate lawyers. And what I'm really saying is I hate that lawyers go after each other's throats all the time. I hate that it has become this sort of game where there's no professional courtesy anymore, and there's some joy to be had if you beat somebody down or kick them when they're down. And I'm not talking the client I'm talking about the lawyers doing it to each other, and even judges doing it to lawyers at times. But then people ask, well, that begs the question, why are you an attorney? Because what I do, criminal defense, is like the last safe land of good attorney and good lawyering, because we have to.
Yeah.
If I screw you today, then you won't deal with me tomorrow, and vice versa. And it keeps itself honest. Money's not involved here.
Yeah.
We're not, somebody hasn't paid me $1 million to go do whatever I can do to screw the other side. It's like they paid me money to defend their case and get a result for them. So it just keeps everybody honest in some weird way in our line of lawyering.
Yeah, and I think we're really lucky in the federal system too, because we have, there's only one political appointee, and that's the actual head of our office. Everybody else is a career prosecutor, a civil servant with civil service protection. They're just, in my career, I have never had any political pressure, office pressure to do or not do a case or to get some particular result. We hold ourselves to high standards. I have enough of an ego. I don't want to go into a courtroom and lose. I don't want to bring a bad case in there in front of judges that I'm going to have to appear in front of for the next 15 years. So there's a lot of internal pressure, but there's never any external pressure for us to do a case or get a particular result. And again, I think it's a very luxurious practice of law that we have here. And everybody that I know, and we've discussed this a lot amongst ourselves in the U.S. Attorney's Office, we recognize like our reputations and the sense from the bar and from the bench that we operate fairly. That's why things work around here. It's one of the reasons why things work.
Well, I agree with all that. It's time for another break. We're going to, as promised, come back and we're going to talk about child pornography. I want to spend some time in that and really sort of get to the meat of those issues. But for now, let's take a quick break and we'll be back shortly. All right, we're back from the break. As promised, we're going to talk about child pornography. Now, you didn't work on this case, but I had Dr. Chris Pulaski sitting right where you're sitting. And he came in and talked about his entire experience with child pornography, felt the brunt of a federal child pornography prosecution. You indicated you can't talk about any of your cases. This isn't one of yours, and I'm not going to talk about his specifically anyway. But I really, from a policy standpoint, irrespective of all the stuff we've covered here and the ground that we've chewed, it's one of those areas where I just have a little bit of consternation with how the law maybe has not evolved as much as it should to adapt to maybe the internet age of child pornography, for lack of a better way to put it. Sure. In other words, the example I used when Dr. Pulaski was here is like, there was a time when I practiced law in the 90s. And I remember if you had a child pornography case, it was a rare, rare bird. And it would be like the traveling child photographer or the truck driver who has this like 8x10 glossy homemade stuff in his cab. And, maybe there's like 20 images or 30 images in that glossy packet that he had, and that was a lot. Yeah. Because it wasn't like it is today where you can have 20 images before you even blink. I mean, before you even hit go or enter. And it just seems that if you just have one movie or if you just have one download, or even in the sense of like, we talked with him a lot about how most of the internet stuff, it's starting to evolve a little bit, but most of it was these peer-to-peer networks like Napster, where if you just turn on the fountain, it comes whether you want it or not, and it goes unless you stop it. Right. And that might be somewhat of an unwitting decision not to stop it. So you could be accused of disseminating child pornography without even knowing you're doing it. And there's a public case going on in Columbus right now where I'm hearing, by public I mean a public figure. I'm not going to mention names, and it's not mine, but I'm hearing people, and he was disseminating it too, and I'm thinking, all right, was he disseminating it like actually emailing,
trading with people,
and trading and going to their house and doing that, or was it like Napster where he had the fountain on and didn't even know it? And here's where I think the federal sentencing guidelines and I guess back to the original theme, some unintended consequences come up, because everybody wants to look harsh on child pornography. Everybody does. And who wants to say we're going to lessen the impact of that a little bit? Yeah. But on the other hand, you have some outrageous sentences on these types of cases. So that's my take. What's yours?
Yeah, I did those cases for about 4 years, and Heather Hill from our office does a really, really good job with those cases now, and it feels like they've gotten worse over the years, and there's probably a good reason for that. I'll say this. I tried to tread very, very carefully on which cases we selected. I know Heather does too. By simply collecting child pornography, you download it, you enter in search terms on the internet, download it on your computer. The possession of that is a 0 to 10-year offense, and the guidelines are very, very high because they give you, depending on the number of images, using a computer to obtain the images, all those are enhancements under the guidelines. That same conduct.
Well, let me stop you there. It's like using the computer to get those images, and one of the things I talked about with Dr. Pulaski is that it's always a computer. So that's an enhancement, but it's always a computer.
There's been a lot of discussion from district court judges, courts of appeal, obviously the defense bar, with the U.S. Sentencing Commission to reform those guidelines. I know there have been some tweaks to them over the years, but it's a continuing discussion for exactly the reasons that you're saying. Like, the nature of these offenses has changed so much. In that scenario, possessing that is a 0 to 10-year offense. Actually downloading that, you're receiving it. Receiving a receipt of child pornography is a mandatory 5 years in prison up to 20 years in prison. There's about this much difference between those offenses. What we tried to do back when I was doing those cases, if it was just a straight downloading case, is we would typically charge that as a possession case. And so there would be no statutory floor that a district court would have to go below. But typically the guidelines would be very high. Even like a run-of-the-mill case, somebody would be looking at close to the top of that statutory range, close to 10 years on a run-of-the-mill case. And I think the Sentencing Commission has tweaked the guidelines. I think the district courts have figured out, about where those cases should be. But those are typically cases where people are going to prison if you're charged federally. So what our office has done is we've kind of come up with our own criteria, the way that we screen those cases, and I would call it, child porn plus. And what I mean by that is we're typically not going to prosecute somebody who's just a downloader and collector of child pornography, even though that's completely prohibited by federal law. Typically, it's going to be somebody who either has a prior conviction, so they've demonstrated either they've collected and done time for this before, child pornography, or somebody who has a prior sex offense, or somebody who during the course of their we come upon their child pornography collection, is attempting to entice minors. They're reaching out through social media, trying to either usually undercover officers or actual teenage girls trying to get them to meet for sexual encounters. So by doing that, we've tried to say, okay, we know this is a pretty big federal hammer we have because if the same conduct at the state level probably wouldn't result in multiple years in prison. We know that. So we've tried to pick our cases very carefully so that it is, we can say this is not just somebody who is a run-of-the-mill child porn collector. This is somebody that has a repeat offender, has sexual misconduct in their background, has been prosecuted for this kind of offense before. But again, that's you don't want it to be the case where somebody walks, to one end of High Street and gets, a probationary sentence, and they go into U.S. District Court on Marconi Boulevard and they get 6 or 7 years for the exact same conduct. We've tried to pick our cases.
Well, that's what's happening, right? And that's the oddity of it. And I get it, a couple things. Dr. Pulaski talked about being in prison with people from all sorts of other jurisdictions. And the numbers that he saw and heard that they were doing, by numbers I mean years in prison, versus what comes out of our district, couldn't be further away from each other. I mean, and I don't know if I brought this up in his interview, but after his case, I got a call from the American Bar Association. And I remember I was in the car, I was traveling with spring break, and they interviewed me for a good 30, 40 minutes on my thoughts on this stuff. The sense of it is this, is that if you were going to get caught and accused of possession or downloading or disseminating or whatever it is, anything child porn related, this is a good place to do it. I mean, in a weird way, because we're sort of at the cutting edge. And I guess we should also talk about, we had a series of cases, the Bisline cases that came through, where we even had a local judge who was sort of at the cutting edge of saying, all right, why don't we recognize these cases for what they are and, more important, what they're not, and maybe craft a way to deal with them that isn't so harsh all the time. And I think what you're saying is you're trying to select now the cases that should be treated harshly, as opposed to the ones that aren't. And one more thing, and I'll turn the mic back to you, so to speak, but you talked about going up High Street or being in your court or our federal court. What you're talking about is the local court system here. Under Ohio law, people call me now. I got caught with child pornography. What's going to happen? Well, it all depends. And they're like, what do you mean it all depends? I was like, well, it depends on if you're going to federal court or if you're going to state court. And I've even had those calls, 5, 6 years ago when you were doing this, where I'd be like, do you know about this? And I'm sort of holding my breath, because if you do, it just means my client's now going to do 5 years in prison or whatever.
Yeah.
And if you don't, I got a shot at probation in state court. And most of the time you did know, and then it was, yeah, but we're not taking it, or yeah, we are, and here's why. But it is that huge disparity of possible results that I think has turned the stomachs of a lot of us on my side of the fence that do these cases.
Yeah, the cases are powerful. I've had to try a couple of these juries, and literally you've had jurors crying when you present the actual video evidence of some of that things. The first time I ever had to view child pornography as part of a case getting prepared when I first got here, the expression boggles the mind, it literally boggled my mind. It never occurred to me that this existed in the world. It's so horrendous when you see adults having sex with 2-year-old children, and just boggled my mind. They're extremely powerful cases from an evidentiary standpoint, and the thresholds to get into our office should be high for that reason, because they're incredibly strong from an evidentiary standpoint. If you just think about what is on your phone or your own computer, that even absence you confessing would identify that this is Steve Palmer's phone and computer. They're incredibly strong from an evidentiary standpoint. So we should have a high threshold, because if we bring one into federal court, people are going to go to prison for a long time, generally speaking. So I think what we've tried to do as an office is try to select our cases, like I talked about before, kind of child porn plus all these other things that are driving that, so that it would be in federal court versus state court. But I don't disagree, and there's been a lot of discussion. It's probably going on 10 years now. There's been this discussion about the sentencing guidelines, changes to some of the mandatory minimums in child pornography cases. It's a fraught political discussion to have. There's not a big pro-child porn defendant lobby out there.
That's right. Yeah. I mean, who would say that this is a worthy activity, right? Nobody. And certainly,
sure,
I'm not intending to say that. Child porn sucks, right? It's horrible. It's a miserable, awful thing that exists in the world, but it does, and people, for whatever reason, view it. And now we're just talking about people who view it for one reason versus another, and how they should be treated, I suppose. But you're right. Who's going to go into Congress and say, we're being too harsh on child pornography cases, and actually be able to take the blowback that comes with that.
And a lot of that stems from the fact that, it scares people. The fact that you have people that are sexually interested in children, or at least on its face, if they're collecting these images and videos, that's what you would assume is going on there. And it's just, what do you do with those people? And I can tell you, I probably did a lot of those cases going back, more than a decade now. People that I prosecuted have now gotten out, served their prison time, did all the treatment programs in, gotten out, and reoffended again, going back into that same thing. And it just scares people. It's a fraught thing, because I don't know that there's a lot of psychological evidence, a lot of criminological, sociological evidence that says that these people can be rehabilitated once you have a sexual interest in children. It's very easy to lump everybody in that views child pornography, because most of us are like, who the hell would ever do that, into that potential predator category, and that scares people. And that's why I think that in the federal system you just haven't seen any lessening of the guidelines or any that. What we try to do, I know Heather strives to do this, I always try to do that, is really distinguish between somebody who is committing hands-on offenses, that is producing child pornography, or actually physically exploiting or trying to exploit children, versus somebody that's a collector. I think there's an obvious inference there as to why they're collecting, but I went to great lengths to distinguish that and say to the court, we're only charging him with this offense. We're not laying at his feet that he's a potential rapist or anything like that. We're trying to limit it to the evidence here, because it's just so powerful.
Sure, and maybe this is we may disagree on some of this, because I'll just put it out there. I have represented lots of people who are collectors of child pornography or somehow get involved. I can't think of one who I would be worried about reoffending. Now, I'm not saying they don't exist. I think those who are collecting it for a particular purpose and viewing it for a particular purpose and getting involved for a particular purpose, it's probably 100% recidivism rate, meaning they're going to do it again. Yeah. Those who are doing it for other reasons is probably 100% the other way, assuming they're getting treatment and therapy for whatever it is, because we could disagree about whether being abused as a kid and looking at it and that impact or that impetus, I suppose, to go look for child porn or stumble on it and be somewhat interested in it. I think that's a different category of folks than the others, the ones who, for whatever reason, God-given or otherwise, like it and have some sort of sexual interest in it for just because. And I guess you said something that was interesting to me, is that right now maybe there's not a great way for the law to distinguish that and divvy up recidivism factors early on or before. But the impact of that decision is lots of people are sitting in prison for a long, long time. And really, it's like it's a therapeutic problem as much as anything. And incarceration is going to do nothing.
Yeah, I'm sympathetic to that point of view. On the other hand, it's really, really hard to distinguish between that group of offenders. When people say that they collect child pornography for reasons other than that they're sexually attracted and interested in children, it would be like you're cracking open somebody's computer and you see 10,000 baseball cards in there, and you say, "Oh, you're really into baseball?" I'm like, "No, I just like hats." Well, it's difficult to believe, and it scares people to think that you have somebody who has exhibited a sexual interest in children because, and I know you know this from your time in defense, it's not the guy who jumps out of the bushes that harms your child. It's somebody who has access and trust. It's coaches, it's priests, it's relatives. And so it's a very scary thing to think that you have somebody who's sexually interested in children, that they view children as sex objects. And when they have a child porn collection, it's not a big leap of inference to glean that. And so I think the law, I think society, it's hard to know exactly what to do with those people.
It is. Now, this goes back to one of the points, I don't remember if we were talking on or off the air here, but so then the question is, what do you do? If you have a certain percentage of folks who are just the people that you're talking about, right? They're the predators. And then a certain percentage that are not. Is it better to treat everybody like predators and knowing that these people maybe get a really, really, really harsh consequence, or do we treat everybody like not predators, knowing that these people may get a lighter consequence than what they have? I mean, what's better for a justice system? I mean, we're really getting to some core questions like that. What are your thoughts on that?
Yeah, I can say that I think that we try to strike some balance in there by the charging decisions that we make. Like what we think we're doing is that we think that we are charging people with child pornography offenses that are potential offenders or have actually demonstrated recidivism in that realm. I don't know if we're always getting that right, but I think that's why it's always important for us to be explaining our charging decisions. And we're good 12 years into really the feds really putting our chips on the table as far as doing child pornography, child exploitation offenses, and I don't know that we've got the balance right yet.
No, I agree. I mean, I think your office has done that, and particularly this is an evolving science, maybe psychological science, perhaps is the best way to say it. And when it first came out of the chutes and the federal government was starting to prosecute these, I think you had more over here where everybody was just getting treated the same because it's this awful thing. And I think maybe there is some eye-opening or some awakening to maybe there's some other reasons why you guys might not want to get involved. But what you're really saying is, look, we appreciate that federal law is really harsh, so we're going to be careful about taking jurisdiction over it. And it's sort of like this default. So if you don't, maybe the state will, and then they can impose the lesser sentence. Yeah. So in some way, I'm not saying you as you, but in some way the government's punting on that. They're saying, well, rather than change the law, what we're going to do is just not take cases and leave them to the entities that might be less impactful on it.
Yeah, I would say this, like the Department of Justice, the U.S. Congress, it's a very big battleship. It takes a long time for it to turn. But I know those discussions have been ongoing, and a lot of very serious district court judges, very widely respected district court judges, have really led the charge on, hey, the tools that you're serving these cases up to us on aren't in the right places, and there's only so much that we can do with the sentencing guidelines and the statutes. Congress is directing some of these statutes shall be mandatory minimums. Is that really the right result? And so I think that's a conversation that's ongoing. I'm sure it's not changing as quickly as folks on the defense side would like. But I can tell you that the Department of Justice, in my experience in dealing with this, is mostly sensitive to this issue. And I think our district would be a good example of a district that's taken that to heart and tried to do the just thing by the way we select our cases.
Yeah, I agree with all that. It just is it's going to be a problem that sooner or later somebody's going to have to deal with. And I think it's to circle it back to some of the other things we talked about. You sort of got this unintended consequence thing. So politically speaking, nobody wants to go on the record and be soft on child pornography or even appear that way or get accused of that, because the other side's going to stone them to death, right?
Sure.
You cannot, I don't say you can't, but nobody's going to be willing, or very few would be willing to actually stand up for that cause. But because of that, we might be impacting a whole group of people in a very adverse way, unintended. And I guess, we're talking about it, so that's something in the right direction. And you're right, our local courts are actually, not courts, our local court is actually sort of at the front of that. And I'm not just saying that because I'm practicing here. I've talked to, like I said, the ABA and others around the country on how child pornography cases are prosecuted. And at least there's some options here to avoid those really, really bad sentencing results. And the other, one last comment here is that you mentioned like touching offenses or contact offenses. Obviously, that's not the ones I'm talking about.
Yeah.
And I think we could all agree on how to treat those or how the law should treat them. But it's an ongoing problem. I think next I'm going to have a psychologist come in here and help me sort of unravel that mess, why people would do it if they're not predators, for instance.
Yeah.
But, well, look, we're about out of time. I really appreciate you coming in. I mean, I could do this all day. I'm not sure anybody wants to watch it.
We usually do every time we get on the phone.
Yeah, we do. We do. It's been a blast. And again, thank you very much. I mean, having both sides of this or having a U.S. attorney sit here at the show is fabulous for us. And maybe we'll do it again sometime.
My pleasure.
All right.
Thanks.